We have to talk about Hunter Biden, who's been indicted for several gun-related charges in the United States District Court for the District of Delaware, because according to his lawyer, he's going to bring some real Second Amendment defenses to bear on that prosecution. Let's talk about this because you need to know about this. This is going to be in the press a lot going forward. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, available not just in hardback, paperback, audiobook, and more. All right, folks, here's the story. Hunter Biden has been indicted. We all know this. United States District Court, District of Delaware. Probably a lot of you see me on Fox News talking about this case and the related issues. But I want to break it down for you in the context of the Second Amendment discussions, because this specifically relates to a gun charge. And this is a classic malum prohibitum crime. What a malum prohibitum crime is, as you know, is a crime that's not evil in and of itself. It's a crime where there's no victims, and it's a crime because our legislators tell us it's a crime, as opposed to malum in se crimes, which are things like murder, rape, robbery, such that even in a state of nature where we lived in a world of no laws, you as a human being would sort of inherently understand that what you were doing had an evil component to it, and that is something that is a malum in se crime, evil in itself, versus a malum prohibitum. Now, this distinction, which we've talked about on this channel before, is very important in the context of the Hunter Biden case, because his situation is a malum prohibitum situation where there's no victims, it strengthens the ability to defend this case because he appears less unsympathetic than, let's say, someone who has done something violent to someone else, and generally they don't look that sympathetic, nor should you be sympathetic toward people who engage in violent crimes. So anyway, with that said, what I'd like to do in this video is simply give you the 3 crimes he's been indicted on, tell you basically what they're about. Then I'm going to explain the defenses to each, including Second Amendment related defenses, so that you sort of hear it from me, so you know really kind of what's going on here. According to the indictment, in October of 2018, Hunter Biden was in Delaware and bought a revolver, and you'll see why that's important in a moment. He bought a revolver from an FFL. Specifically, according to the indictment, he purchased a Colt Cobra 38 Special. Colt Cobra 38 Special revolver. You'll see why that's important in a few minutes. So, at the time, according to the indictment, he was using and or addicted to a controlled substance. Basically, he was an illegal drug user at the time of his acquisition of this FFL, from the FFL of this gun. So, as a result of that, this gave rise to 3 charges. The first count is under 18 U.S.C. 922A 6. Just to jog your memory, Title 18 is the criminal code, the federal criminal code. So whenever you hear me say 18 U.S.C., it stands for 18, which is the title. U.S.C. stands for United States Code, and then the section. So 18 U.S.C. 922A 6 is really Title 18 of the United States Code, and then the relevant section. So the first count is Section 922A6 that says it is illegal for any person in connection with the acquisition or attempted acquisition of a firearm or ammunition from a licensed firearms dealer to knowingly make any false or fictitious oral or written statement or furnish or exhibit any false, fictitious, or misrepresented identification intended or likely to deceive such importer, manufacturer, dealer, or collector with respect to any fact material to the lawfulness of the sale. The indictment here says that because he did not disclose that he was a drug user, an illicit drug user, or addicted to drugs, on his Form 4473, which, as you all know, is the form you have to fill out before a NICS check can be passed or can be even done, because he answered no, he's not a user of drugs and whatnot, that, according to the Department of Justice, was false, materially false. So that's the first count. The second count is very similar to the first count and may actually merge together, but we'll talk about that in a few minutes. The second count is under 18 U.S.C. 924A. The first one is 922A. The second count is 924A, which is someone who has knowingly made a false statement or representation with respect to the information required by this chapter to be kept in the records of a person licensed, i.e. an FFL. So you see how they're very similar? Both count 1 and count 2 deal with lying to the government, lying to the FFL, who's effectively function as an agent of the government doing these background checks, right? They're both lying. So count 1 and count 2 both involve lying on a form 4473. One speaks to whether or not it's a material fact as to whether or not someone's eligible to have the gun. The second one speaks to information that relates to the background information or the records to be kept by the FFL. They are very similar. They may actually merge together ultimately, although that's not what the case law says. But again, we'll see what happens. But for the moment, they're independent counts, and both involve Hunter Biden allegedly lying to the FFL when he acquired the firearm in October 2018. Count number 3, though, is involving the possession, the illegal possession of a gun as a prohibited person under 18 U.S.C. 922G. We've talked a lot about 18 U.S.C. 922G recently because that is what is being presented to the U.S. Supreme Court in the United States versus Rahimi case. That case dealing with 922G8, the domestic violence restraining order provision. But here, Hunter Biden has alleged to have violated 922G3, which is a person who is an unlawful user or addicted to any controlled substance, whether it be crack, cocaine, any of these things, and that the allegation is he was indeed an unlawful user of and addicted to a controlled substance at the time he acquired the gun and took possession of the gun in October 2018, again, the gun being a Colt Cobra 38 Special. So again, first 2 counts about lying to the FBI, lying to the FFL and to the federal government, and count 3 is the fact that he was allegedly a unlawful user or addicted to drugs and took possession of the gun. That's count 3. So those are the 3 counts that Hunter Biden has been indicted on. Now, what has his lawyer said? His lawyer was a very famous, prominent lawyer, Abbe Lowell. This is what Abbe Lowell said. He said that he thinks the statute here is, quote, likely unconstitutional, and he expects, quote, the case will be dismissed before trial. He goes on to say, Hunter Biden's lawyer, that while the criminal statutes, and I'm paraphrasing here, while the criminal statutes cited in the indictment are clear, it's quite likely that this is unconstitutional because of recent appeals court rulings that drug use alone should not automatically prevent someone from obtaining a gun. Abbe Lowell, the attorney, says, quote, the only change that has occurred between when they investigated this alleged crime and today is that the law changed, but the law did not change in favor of the prosecution. The law changed against it, period, close quote. And of course, what Abbe Lowell is referring to on behalf of Hunter Biden is, among other things, the Nice-Harper versus Bruin case and some of the related cases that came after that that are much more aggressive in terms of requiring that modern-day gun control laws comply with the text and history of the Second Amendment, which we know a lot of these do not. So in light of that, let's take a look at the possible defenses. By the way, before we get to the defenses, I want to remind you of one thing. How many of you have seen that famous photo of Hunter Biden standing there apparently naked with a gun held down by his side? Again, this photo, which supposedly I think came from a laptop of his, by the way, side note, what was that gun that he appears to be holding in that photograph when he's naked? That handgun appears to be a semi-automatic pistol. That's important to keep in mind because while the photograph of him naked with a semi-automatic pistol is out there, he's not been indicted for that gun. He was indicted for having and acquiring in October 2018 a revolver. So one wonders whether or not there's potential criminal charges that could be coming down the pike with respect to Hunter Biden and that semi-automatic firearm. We won't know. Don't know. But that photograph does appear to be out there, and one wonders when that was taken and what was going on. But keep in mind, that is a second unrelated gun to the revolver he's been charged for in Delaware right now. Okay, with that said, let's talk about the potential defenses. The first one I just want to touch on quickly is the lawyers for Hunter Biden say that there's a deal that was already struck by the Department of Justice and Hunter Biden, a contract, if you will, that he would go into a diversionary program. And therefore, because the Department of Justice signed it and Hunter Biden's lawyers signed it, that diversionary program, that diversionary agreement is in place. It must be honored like a contract. Now, what I've said on Fox News about this before, it's quite interesting that if you actually get into a litigation in court as to whether or not that's a binding contract, that could very well give rise to discovery of the members in the Department of Justice who gave rise or approved on that quote-unquote deal with Hunter Biden. So it's quite interesting that some of the information that, for example, the House Republicans are trying to get access to about the Department of Justice and what they did or did not do vis-a-vis Hunter Biden, one wonders if that's going to come out in the context of a fight over whether or not there was an agreement in place between Hunter Biden and the Department of Justice to send him into a diversionary program and thus avoid these 3 indictments. So the first defense is going to be is the Department of Justice agreed they would not bring these charges. They put him into a diversionary program, and he's doing the diversionary program, so these charges should not be had because, again, there was an agreement not to bring the charges. Now, the government is probably going to say is no, these charges are part of a global deal that we had, and when Judge Noriega in Delaware said no to the overall deal, that meant that the whole deal fell apart, including but not limited to this diversionary program that dealt with these gun-related crimes. Nevertheless, we'll see how that plays out. But let's go beyond that and talk about some of the Second Amendment defenses here. The first Second Amendment defense, speaking specifically to count number 3, which is that you possess a firearm while you are a user, an unlawful user of a drug or addicted to a controlled substance. We understand that there is simply at the time of the founding in 1791, no, I repeat, no historical analog laws that said that you could not be addicted or a drunk or whatnot and also possess firearms. So just at the first level, there's a very strong argument here that because of the text of the Second Amendment is clearly implicated because we're dealing with whether or not to possess a firearm, which means the right to keep and to bear. So the text of the Second Amendment is implicated by this gun charge, right? It's a gun crime. So once the text is implicated, as you know from this channel, what happens is the burden shifts. The burden shifts to the government to do what? The burden shifts to the government to show that the modern day gun control law they're trying to uphold, in this case, 18 U.S.C. 922G, that you can't have a gun if you're a prohibited person because you're addicted to a drug or whatnot, or you use a drug illegally, that there is some sort of historical analog law at the time of the founding that says this kind of concept is part of a long-standing tradition, and 20th century stuff doesn't count. It's got to go back to the time of the founding. Well, obviously, if you go back to the time of the founding, we know, for example, that the entire American Revolution was largely run out of bars and taverns. We know that John Adams and his cousin, Sam Adams in particular, of the beer company, Sam Adams, right, I believe. Sam Adams actually had a bar and a tavern, and they would hang out and they would drink beers, and they would talk about the revolution. And certainly no one banned guns in these places. So I don't think you start to see any kind of restriction on guns in any respect associated with substances or drunkenness or any of this, I think, until the late 19th century. And we've talked about how late 19th century historical analogs don't count unless they confirm the freedoms associated with the 1791 Second Amendment. They cannot contradict or undercut it. So really the only historical analog laws that could be relevant here to help the government have to arise at the time of the founding in 1791, and those simply do not exist. There is no historical analog that I can tell or I've ever seen that says that an unlawful user or someone addicted to drugs or alcohol or any of that stuff could possibly be denied gun rights. There may be some arguments, I suppose, that if you're drunk and have a firearm, that could be a problem, and that might be upheld under some notion of dangerousness. But again, we don't need to get into that in the context here because there's no suggestion that Hunter Biden held these revolvers while he was impaired, let's say. This is a charge that just says that he was addicted to drugs, he was a user of unlawful drugs, and he possessed a gun. They didn't connect the dots. He just said that that's it, and that's enough for a crime. But again, I think that the Second Amendment argument involving count 3 is pretty strong. And that gets rise to counts 1 and 2, which are lying. Now, here's the kicker. You may say to me, hey, Mark, counts 1 and 2 are lying. Obviously, you've never been allowed to lie to the government. That's never been appropriate. But here's the thing. If you look at count 1, let me read a critical phrase from count 1 dealing with 922A6. It says, with respect to any fact material. With respect to any fact material. to the lawfulness of the sale or other disposition of the firearm. And why do I say that? Think about this for a second. If you have to and prove that a fact is material, what does material mean? Material means something that could influence the outcome one way or another, right? It's relevant. It's material. It matters. Counts. Well, let's just play this out. The government is arguing that count 1 and count 2 that Hunter Biden represented or misrepresented a material fact, i.e. that he was a user of illegal drugs or he was addicted to drugs, controlled substances, right? They argue that those are material facts. But how are they material facts to whether or not you're allowed to have a gun? Well, it seems to me that a strong argument can be made that the only way that Hunter Biden can be convicted of lying to the government by making a misrepresentation of a material fact is if count 3 is constitutional. Only if 922G3 that says that if you are an unlawful user of or addicted to any controlled substance, then you cannot have a gun. Only if that is constitutional in the law of the land and appropriate and valid. Only if that's true can, at that point, if it's true, yes, then lying about being addicted or an unlawful user of a drug could be material to the acquisition or disposition of a firearm under counts 1 and 2. But if count 3 is struck down as unconstitutional on the grounds that there's no historical analog law that says that you can't be addicted to a drug or a drunkard or whatever it is, and as at the time of the founding, right? There's no historical analog law at the time of the founding that says if you are addicted to drugs or whatnot, or you're an alcoholic or whatnot, then you can't have a gun. If there's no historical analog law in 1791, and count 3 is dismissed for being unconstitutional, then it seems to me that lying about an immaterial, non-material fact means that you also can't be convicted under counts 1 and 2, because count 1 and 2 presuppose that you're lying about something material, something relevant, something important. But once count 3 disappears, counts 1 and 2, you're no longer lying about something that's material. So I could see these 3 counts being all dismissed. That's right. And what's going to be very interesting, of course, is to do this is going to require Hunter Biden's lawyers to make arguments that are going to be fought against by none other than Merrick Garland and the Biden Department of Justice, who bend over backwards to, shall we say, harass gun owners at every turn. So it would be most ironic if Hunter Biden and his lawyers, and he has good lawyers, by the way. This is not going to be some public defender somewhere. These are going to be top-end lawyers paid big bucks. They're going to come, and trust me, they're going to be watching, channels like the Four Boxes Diner. They're going to be doing their research. They're going to be putting together the case. They're going to look for every single stone and look under every single stone and turn over every rock to find a defense for their client, Hunter Biden, because they're good lawyers. They're top lawyers. They're private lawyers. They're big-time lawyers. They're going to be looking everywhere, and they're going to come into court ready for, to hunt bear. That's what they're going to be doing. And they're going to be making the best possible arguments from all across the country, and they're going to be using the information that they're going to get from top Second Amendment scholars to fight the Biden administration, which is going to be most ironic if it turns out that Hunter Biden undercuts tremendously the gun control movement in America and the gun control advocacy of his dad, Joe Biden, and the Vice President Kamala Harris. But only time will tell as to how this thing plays out. But yes, I do think that Hunter Biden's got some real strong Second Amendment-related defenses here, and I think he's going to advance them, and they're going to have really strong lawyers, and they're going to put in a good fight, and we'll see what happens. But this is why I wanted to give you the context and to lay this all out, because it's important that you understand this is going on, because it really could potentially help our Second Amendment movement if Hunter Biden kicks his father's butt in court on these issues. So, all right, folks, hope you learned a little bit something here today. Don't forget, if you haven't followed me on Twitter/X, check me out at Four Boxes Diner. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.